Good morning, everybody, and thank you so much for joining us for this AJ seminar. I'm really excited. It's a great topic, and we've got a stellar panel. So, without further ado, I guess we should get going. So, obviously, this webinar is about business in practice and how to manage risk, and it's run in association with CMAP. So, thank you very much to them. I'm Curly Barker. Some of you might know me from my column in the AJ. I'm a writer, broadcaster, and a columnist for the AJ, and I'm delighted to be joined by our stellar panel that I've introduced to you now. Our first panelist is Assad Maqbool, who is known as Mac, and he is the partner and head of real estate at Trowers and Hamlins. Our second panelist is Laura Cook of Laura Cook Consultancy, who was a finance director at Make Architects for over 14 years. Our third panelist is Tahira Roof, who is the associate director at RCKA, and last but by no means least, we've got Joe Emmanuel, who is Head of Architecture, Engineering and Construction at the software company CMAP. So welcome to our panel, and many thanks indeed to CMAP for making this webinar possible. So what we'll be talking about today? Well, we're going to be talking about managing commercial risk, and it's a key part of running any successful practice, from planning for the changing in resource requirements to negotiating and following up fee claims. What are the current best practices and approaches to reduce and mitigate commercial risk? And that's what we're going to be exploring and covering today. So some of the topics that we're going to be covering include, and we're going to be looking at an overview of where key commercial risks lie, both financial and contractual. We'll be looking at fee claims, the potential pressure points, litigious clients, and the reduction of loss. We'll be looking at managing subcontractors and sub-consultants, the role of PII across your business, and understanding and planning for resource requirements. Now, during the webinar, I'll be inviting each one of our panelists to do a short presentation. After those presentations are finished, we'll have a quick discussion about the key issues, and then we'll open it up to questions from you, our audience, towards the end. So please do use the Q&A function to post your questions to our panel, which you'll find at the bottom of your screen. So, without further ado, shall we get started with our first presentation? And first up, I would like to invite Mac from Trowers and Hamlins to kick things off. So, thank you, Mac. Over to you.
Great, thank you, Cunley. I'll just do a slightly clunky sharing of screen. Hopefully that's worked. And I should also, forgive me, Cunley, I'll make a slight correction to your introduction of me. I am a partner at Trowers and Hamlins, and as of today, I've been here for 21 years, and we are a real estate focused firm, but I am actually a construction lawyer, not the head of real estate. I think my colleague Suzanne Benson, if she sees this recording, would be wanting me to correct that. So I am a general construction lawyer and do construction contracting, advice on construction contracting of all different kinds of projects. And I have also, for a number of years, been sitting on the Association of Consultant Architects Alliance Steering Group, which focuses on collaborative working contracts. And I've recently, last year, rewritten the ACA's standard form of architect's appointment. Today, my take on commercial risk in practice, of course, focused on the construction contracting. And so briefly, I'm going to talk through the contractual treatment of commercial risk. And I'll also just flag a couple of other topics that we may want to discuss a bit further later, or you may have questions about, as they are the things that I've been focusing on over the last few years, which are the Building Safety Act and collaborative working. So the main point from a construction contracting perspective is about the contractual risk of breach of obligations, and that possibility of liability of an architect flowing from breach of its obligations. And the more basic point that underlies that is that an architect will have failed to carry out its obligations with reasonable skill and care, the reasonable skill and care expected of a professional designer. And that phrase you will have heard a number of times, and it comes from both the Supply of Goods of Services Act 1982, but there's also an implied term, even if it's not stated, not just from statute, but also from common law, going back to what is negligence. And negligence is effectively failing to carry out your services with reasonable skill and care. So that I think leads to a number of pertinent points. The first is being very clear about what your services are. And second, in terms of the wording that you're using in your contracts about that reasonable skill and care, a lot of that will be to try to mirror your professional indemnity insurance wording to make sure that they exactly align so that you do have professional indemnity cover. And from a contractual perspective, what you want to do is ensure that there is no implied fitness for purpose, so that there is no duty of care that is greater than reasonable skill and care, because there is some question, although it tends to be in sort of complex M&E engineering design, but there is some question about whether something is above that reasonable skill and care because it's just a strict obligation, in which case there is a question about whether it's covered by PI insurance. The other points that I briefly wanted to touch on were that, of course, a lot of contractual risk relates to reliance on the work of others, reliance on inputs of others at a certain time, and to have something in terms of a contractual matrix that allows you to rely on work of others and to rely on information gathered from others in the construction team is an important part of managing and mitigating the risk of complying with your own obligations. But I also wanted to just point out that there is, as well, in common law, an implied duty to warn. And that is about seeing the work of others and noticing that there is an error within that work. And underlying your obligations, there is an implied duty for you to warn others of mistakes that you find. And so that leads to practical points about the extent of access to information provided by others and contractual obligations about explicitly reviewing the work of others, and also leads into quite a detailed topic around net contribution clause, so the ability to claim contributions of others should there be a liability that falls to you. Again, briefly, one of the key risks in any designer's appointment is that there's infringement of intellectual property, and so you will want to be clear about licensing. In any construction contracting, including appointments, you would want to have a good and proper liability cap. That means that not everything is a balance sheet risk for you. And there is, of course, the general principle about what you are required to carry out, and indeed by when you are required to carry out services, and whether those are within lump sum fees or otherwise be explicit about occasions when additional fees can be sought. So that is a general overview of construction contract issues. I just wanted to, as it's been this, well, without question, the most talked about issues recently has been the changes being brought in by the Building Safety Act. So just very briefly to touch on this, you do now have statutory obligations in respect of competence and statutory obligations of designers and principal designers, and underlying those within the Building Act 1984, there is statutory liability, unlimited potential for fines potential for imprisonment, and of course those things are concerning. What I would say is that what is telling here is the professional indemnity insurer's response to the Building Safety Act, which is generally that these things are that the professional liability is covered in respect of those additional services that are required in order to fulfill the statutory obligations. And part of the reason for that is that underlying the Building Safety Act is and in looking at those new obligations and trying to understand those new obligations, underlying the Building Safety Act is aimed to actually reduce risk and to put in processes that will mean that there will be fewer claims because fewer of those risks will crystallize. And finally, just a word about the thrust of my construction practice, which is about collaborative working, and the things that I've done with the ACA, with the Association of Consultant Architects, have been about collaborative working. Again, similarly, when you're looking at those new obligations under the Building Safety Act, look at the contractual processes that you're being required to fulfill and see whether those things actually try to reduce the chance of risks crystallizing and also seek to manage risk. And one of the important parts, including in the collaborative procurement guidance issued by DLUC some 3 years ago now, in response to the Grenfell inquiry, you will have seen that there is an emphasis on collaborative working as a way to reduce risk, and an emphasis on a managed pre-construction phase and managed design development process in order to reduce overall risk on projects. So that was a very swift summary. And now I shall, as I hand over to Kunle, I shall try to find the stop share button.
Matt, thank you so much. That was really interesting. I don't know, I'm sure the rest of the audience have got loads of questions for you. I've got quite a few written down here, but we'll tackle those later on. But thank you very much for that really interesting sort of summary of risk and what we need to be looking at. And next up, we have Laura. And Laura, I would like to hand over to you for your presentation. Thank you.
Have I stopped sharing?
You have, Matt. That's fine.
Oh, good. Okay.
And have I started sharing? No.
Not yet.
Oh.
There we go. Is this
Excellent, thank you. Right, I'm going to zip through this. So I was 14 years at Make, as Kunle said, and I now do what I do for Make for other architects. So I'm a fractional FD, and I also focus on employee-owned companies, and I do what it says on the slide. Risk. Okay, so I think everyone's going to be talking about the same themes. We haven't seen each other's slides, but if you see commonality in them, it shows you that we all think the same about things. Right, my key thing is setting the fee right in the first place. Don't race to the bottom. There's no point. We're all in this together. Architects, I don't think, get paid enough as it is. And yeah, it doesn't do anyone any good if you have your percentage of construction value too low. Always factor in some buffer as well. If you want to do a job, which is sort of a portfolio job, let's say, I always used to hear, we'll go for break even on it. What you must do is add in some buffer as well, because no project runs as you think it will run. So if you do a break-even fee, assuming that it will go, you know, for as long as the client says, well, it won't. It will go on, and there'll be more iterations, etc., etc. So it's just factor in some buffer, break-even plus a little bit to get low profitability, and you might not make a loss, but you probably will, to be honest. Right, and the key thing is to look at past projects to check your profitability. So look at your timesheets. Make sure you count every hour as well. Don't say you don't get paid overtime. If you've done a project and it's profitable, but everyone's been working 16-hour days, if you actually factor in all those hours worked, it's not profitable. So don't cheat yourself. Charge the right fees. Right, next, it's all on the same lines. Project overruns. And Mac talked about some of these. Time extensions without fee adjustments devastate margins. So set clear boundaries in your contracts. Design iterations. Too many options or revisions erode profitability. So the key thing is to limit your iterations. Don't say at concept design, you can have as many as you like. No, say you get 3 options. And this is where you can start to sort of get back fees. Your fee might be quite low, but if you start charging more for iterations, etc., you can start to make back some of that fee. But you must speak to your client in advance of all of this. You've got it set out in the contract, but then speak to your client again. They don't want surprises. You won't win, basically. Scope creep. Small unpaid additions accumulate rapidly. Document all change requests formally. Share them with your client. Do not do fee claims at the end of a project. Talk to your client about it as you go along. Without a doubt, get to the end of the project and say to your client, hey, the project overran, you changed it from a hotel to service office, and the program went on for 2 years rather than 1 year. They will undoubtedly say, and we'll sue you. The project went on for 2 years because it was your fault, etc. But if you have an open conversation with them as you go along, there'll be no surprises and it'll be easier to get extra fees. If your client at any point does make a hint of suing, please speak to your professional indemnity insurers before you do anything. Which brings me on to professional indemnity insurance and contracts. Michael already talked about limiting your liability. Your PI insurers might say, hey, you have 10 million each and every, and they're uncapped. Your clients quite like this because then they can go for, hey, I can go for like 50 million, 10, 10, 10, 10. Just remember your excess. You might have a 50K excess on each of those, and that starts to add up, and that hits your bottom line and will wipe out your profitability. So what you'll want to do is cap your liability in your contract. So even if you have uncapped insurance, you want to cap your liability. So that could mean you might have your PI insurance says you can have as many 10 millions as you want, but in your contract, you might say 10 million for each claim, but only 20 million in the aggregate. Check your PI for restrictions on cover. Most insurers now have restrictions on fire and cladding. And then sub-consultants, they need to be back to back with your contract. Everything in the contract needs to be back to back. If you're passing down things to your sub-consultants, risk, etc., passes down, you've got to watch what their caps on liability and their exclusions are and make sure they don't have, let's say, capping at 5 million and you've got it 10 million, because guess what? You will be picking up that difference. Which is on to my next bit on sub-consultants' financial risk. So on this, you want to credit check your sub-consultant. They could go bust, and then you will have to pick up everything. So you're liable for all the risk, etc. Their fee. What you want to do is, if your sub-consultant is charging £2,000 a month, you want to put an uplift on that, because they will. Basically, it's an uplift for the risk and uplift for all the admin involved in managing and reviewing their work as well. If you don't do that, you'll be at a loss. Payment terms, you're not allowed, it's illegal to do paid when paid. So just remember that. If you've got a slow paying client, you're going to have to pay your subs on time, and that can affect your cash flow. So what my main advice would be, don't have sub-consultants. But if you do, follow exactly as I said. Sorry, that was a whirlwind, but a lot to get through. And back to you, Kunle. Stop sharing.
Thank you very much for that. That's absolutely fascinating. I can tell already we're going to have a great conversation at the end of this. Thank you. And next up, we have Tahira. So can I hand over to you, Tahira, please?
Hello, I'm going to share my screen too, so bear with me.
Thank you.
Let me know that you can see it.
Yeah, we can see that. Thank you.
Perfect. Following on from Laura, who said, don't have sub-consultants. Sometimes you end up having them. So my focus today is going to be about having sub-consultants and how do you manage risks with them. So the question is, why are architects managing sub-consultants from the beginning? We found that increasingly our clients, especially the clients that we work with, public sector clients, are asking us to take on the role and asking us to appoint and manage sub-consultants. So that would typically include design teams, so engineers, specialists, sustainability experts, and a bunch of other people. Clients want that single point of contact, so one contract, one lead, less admin on their side, especially, you know, when they are local authority organisations. And this is not the only reason, but one of the main reasons is they don't have capacity themselves in-house to be able to take on the complex design team. So the architects often feel or seem like the natural coordinators, because we're already doing the coordination and leading anyway. I think there's a sense that as architects, because we are coordinating, there's a greater efficiency if we also manage the consultant team and manage the invoices that are related to them. But also this is a risk and liability shift from the client into the architect. Russell Curtis, who wrote an article for the AJ actually about this, just to quote, in our experience, more than half of our fee income has been paid out to sub-consultants. And as a consequence, we've had to pay larger insurance, PII insurance premiums, and we've had to manage dealing with large sums of money coming in and out of the business, which has been a real issue for cash flow, especially if you're a small practice or a medium-sized practice that we are. Going to move on to the next one. So what have we learned along the way? What are the tools that I would recommend to people who have taken on sub-consultants? The baseline, I mean, the things that Laura, you've said is bang on. We need to be able to have really good set of fees, clear scopes, and realistic fees, clear sets of scopes, and a really prescribed set of deliverables. And with that, a design program, because that's your baseline. That's the bit that sets out what you're going to, if there are deviations or changes, that's the baseline that you always set your costs against or additional fees against. We've also realized that actually the process isn't simply an administrative role that when we first went in, thought it was, well, you know, we're just administrating money and people's fees, etc. But in reality, it was more than that. And one of the things that we had to do and developed as we went along were a few little, I guess, processes and tools. As a starting point, picking up on Laura said, was the kind of notify your clients. If you think there are changes, what should you do? So some of the projects that we've worked on have asked for kind of a contractual process of an early warning notice, which is about tell me when it's going to happen, what's about to happen, notify me as soon as you know, and in the region of what it might cost, even if you don't know, but tell me in advance. And we've actually taken that on board with lots of other projects. Not all clients want it, but it's been really helpful. And actually what we do is when we do know there might be a change or there may be a fee claim, we notify through an email, and then we'll put together a tracker that we populate and we maintain and we share with our client. And that's been really helpful and got us out of a lot of hot water. The other one that we do is something called monthly status reports, and it's something that we've developed at RCKA, and that's kind of born from the situations where we've actually done the work. The projects have been so fast-paced, and we've done the work, and we haven't gone away and asked them for fees before we went and done it. So what we've done is retrospectively, we've gone to clients and kind of said, well, can you pay us money because we've done extra work? And that's come in quite cold, and it's been a lot of kind of time spent trying to gather evidence to prove why the work that you've done warrants extra fees. By having a monthly status report, you're able to kind of itemize, and you do this on a month-by-month basis, like an administrative kind of documentation of what exactly you've done over the course of the month, the numbers of meetings you've had, who you've met, and the numbers of hours you've worked on it. And that gets sent out every month. And that becomes, should you want to go back for a retrospective claim, that becomes a really good documentation to go fall back on. And then we obviously have managing a kind of change control process. And that is pretty much administrative. It's all about, you've done the early warning notice, so you've done the monthly status reports, and actually putting in a claim for extra changes, for example, becomes a, you know, like an administrative process that you put in and you kind of share with your client, and then an invoice will follow on. There was a survey that was done by the RIB that said 43% of the clients said that an unclear scope of responsibilities was a key cause of disputes or dissatisfaction on projects. So really urge that people have a good set of baseline documentation and manage your risks as you go through. Manage expectations and always forewarn what's about to happen before it's happened. But like with everything, not everything goes right. I want to share with you an example when we did have a dispute. So this is a project that we sub-consulted about 10 different consultant teams. I led the project. This was basically the clients refused to pay for their MEP lighting report. That was a validation requirement, planning validation requirement. Their reasoning was twofold. One is, well, you should have included it in the scope, and it's not included. And because of the scope for that specific element of the MEP's work was ambiguous, it meant that we couldn't justify it robustly as we would want to. The other thing that they also picked up on was an early warning notice wasn't formalized. What they wanted, an email, wasn't good enough. The process of actually formally putting it on a tracker and then sharing it was what they needed. Therefore, it didn't justify, the early warning notice wasn't justifiable. And so they refused to pay, and we were obviously in negotiation. In other disputes that we had with the same client around pay and being paid, we've had to trawl through kind of emails and being able to justify our position, and at the same time we've been able to kind of enter into kind of very kind of respectable mediation situations just between the client and ourselves. So it hasn't been ever gone out, you know, outside of the client and architect teams. However, in this scenario, they were absolutely digging their heels and weren't going to pay. And bearing in mind, it wasn't that because the sums of money was very large, it was only £1,500. It was the principle that they set out that you didn't follow the rules, therefore we're not paying. So, and we also couldn't do the thing where pay when paid situation. We couldn't absorb it. So we went back to our consultant team, MEP team, we explained what happened. Unfortunately, we were able to have that amicable agreement that because the sum of money was quite small, they wrote it off. But the point here is, in the end, you should, I mean, if you can resolve your disputes through negotiation, try not to kind of let it go out of hand. But actually, there's also these risks that we're taking on. There's a stress that you take on from managing these things, and we're architects, not lawyers, right? And there's also a reputational cost. We want to maintain our relationships both sides, both with our client and with our consultant team. And then my final slide is, should we rethink the role? I think this role that we do, where we take on sub-consultants, is beyond admin. We charge a 10% markup for the work, but actually, if you look through timesheets, it is not a 10% market. It goes way beyond. For me, it sits as a project manager role, actually, and architects absolutely don't get paid the scale of costs that they incur with what they put out as their fee. They just don't get paid that at all. We carry so much hidden risks. So situations where there's an ambiguity in one small area of one of the 10 consultants, you will be liable for the costs for that. And actually, the scale of money that comes through to pay our sub-consultants is kind of really tricky for a medium-sized, small-sized business, because you need to make sure that you have the cash flow to be able to pay people. You know, even if your client doesn't pay you on time, or if doesn't even want to pay you sometimes. So my question back to our industry is, should architects embrace a hybrid PM role for fair fees? Or should we push back and redefine the extent of our architectural service? Thank you.
Sarah, thank you again. What another fascinating presentation. Thank you very much. And now I'd like to hand over to Joe, if I could.
Thank you, Conley. I'm going to attempt to share my screen now. It should go through very straightforward. And it is on there, I believe. Oh, desktop 2, that one. There we go. Share. Great. Hopefully everyone can see my presentation. Bit about me, first of all. I've been in the industry for 35 years plus now, 20 years within various architectural practices. 10 years I had my own consultancy, helping architectural and engineering practices to manage their business, change management, systems implementations, etc. And for the last 5 years, working for CMAP. So I've seen the industry through many economic cycles. I've been through the pain of making redundancies. I've dealt with the difficulties of sub-consultants wanting payment when you haven't been paid yourselves. So my presentation is really based upon risk from a practical point of view as I see it. So I've got far too many slides, I suspect, as I'll rush through these, but let's look at the projects. So, the managing risk, there's not only commercial and contractual risk, there is also reputational risk as well, as was alluded earlier. If you end up having to sue a client or be sued by a client or a consultant, your reputation is not going to be helped. So will that project negatively impact the reputation of the firm? So I split the project into 3 areas. The bidding phase, which is by far the most important, because that's where you actually find what your fee is going to be, what the scope is, etc. The designing phase and then the construction phase. And one thing I always like going back to is, because I hear it so many times, the fee was too low, so we did the project anyway. Well, is the fee too low, or is it just the scope is too broad? Are we doing too much? So always bear that in mind. So let's look at the bidding. So bidding phase, right? So you've got some risks there. So you've got the client risk. Do you know your client? Not just not in an anti-money laundering way, but have you worked with them before? Have you got any idea from other peer groups about what they like to work with and what they like to pay? The site itself, the project itself, do they own that site, or are they going to flip it once planning's been achieved? Which is fine, but you need to understand that for the profile of the project fees. Do they have funding? If they're a developer, are there certain funding hurdles? Again, trying to understand what the client is and what their ability to pay is. Then you look at the project. So what are the risk points? So alluding back to that funding or the owner of the site, if you profile your profit earning potential evenly over the project, that's fine. But if you actually have to scope it so all your profit is earned on the construction phase, what happens if the project stops? What happens if planning isn't granted? You'll end up with, great, a fee of £100,000, but your cost will be £110,000 because you're expecting to make that profit up in the later stages. Again, see it so many times, set a bid budget, a resource budget for that bid phase. Understand how much it's going to cost. Don't let it be a nasty surprise at the end. Oh, we actually spent £50,000. Because all that means is the pressure will be on to take the project anyway, regardless of the fee, because you spent £50,000 trying to win the project. I have an issue with this stage 0 and stage 1. Should there be a time charge? Are we doing more than we should be doing? Are we being the client's therapist? Are we being their business plan manager? So again, think about the project. What do we know about it? What does the client know about the project? What do they want? And always test the full fee against the resource costs. That's the way that's the way you avoid any nasty surprises. And actually, again, on the project on budgeting, even if you say, actually, do you know what, we're going to do this project because it's an excellent project, it's a project we want to publicize, it's just what we do, or it's a new sector. Even if you know you're going to make a loss, set that budget to make a loss at the start, so it isn't a surprise. Manage the expectations, set achievable targets for your teams. And then on the contractual side, which I'm sure Matt will talk more about, PI insurance, design team, check their PI certificate comes in every year. There's been no exclusions added onto it. I always like, I don't know, Matt will probably tell me otherwise, but I always like within the terms and conditions that go out to a client to start with saying, in the event that we are instructed without a contract signed, we will carry this work out under time charge, which may be offset against your fees once the contract is signed. Because we all know too many times we start work without a contract and then it becomes a grey area. Project cash flow. So this is where you're saying, actually, do you know what? We have to pay our salaries on a monthly basis regardless. We do work for a client, we work through the month, we send the invoice out, maybe 30 days they'll pay, but in the meantime, we've had to pay our salaries. So you are funding the project for that client. It's inevitable to a certain extent, but understand it, because you have that with all your projects, you've got a cash flow problem for the business. That is a quick run through. So the next one, right, design phase. Really, this is, sub-consultant appointments, very useful, interesting points from Tahara on that. Back-to-backs must be fully back-to-back. Check their PI, no exclusions have suddenly appeared on their latest PI certificate. Sign off of stages. Just really understand that once a stage is complete, get it signed off by the client so they can't go back. Oh, design development. So it's just a way of controlling that process. Budgetary control, always look at your resourcing. Reforecast, it's an early warning system that things are going wrong. Payments, do you know your debtor control procedure? Have you got one? Does the client know it? Is the client not expecting the fact you send a letter out to the client after 7 days of late payment? Scope, create variations, control. On those, I always have in the past actually sent out a note to the client saying, we have carried out this extra work for you. These are the hours. This is the time charge cost. We do not propose to invoice you at this point in time, but we may at a future time invoice you for it. Because they need to know, to be fair to the client, you can't at the end of a project say, oh, by the way, we did some extra work for you. You've got to let them know, and let them know in a monetary style as well. And then BSA golden thread, this is about managing information. This is about managing information, managing and recording information, all those changes that happen in design. Because no doubt I expect the requirements will spread to other project types as well. And it's a good process to say, no, this client asked us to use this consultant and this consultant told us this. Because Grenfell was about spreading blame, or the inability to spread blame. So this is your chance to secure there won't be any future risks. And in terms of legal disputes, and I've done a number of legal disputes, but it's always grey areas that reach a settlement. Very few claims go to court. It'll be settled. And they won't be settled on fact. They'll be settled on grey areas. Oh, that wasn't included in the original scope. You didn't ask us to do it. It's those grey areas that managing information really helps to avoid. Okay, construction phase, really it's a case of monitoring, reporting and recording. Again, Building Safety Act, any design or any materials changes on site, report and record. If you're on a percentage of construction cost fee, will you actually ever see the final construction cost? Because the relationship is often, most always, between the QS and the client. You have no contractual requirement to see that. So if it suddenly goes up by £200,000, will you ever see it on which to base an invoice?
Joe, sorry to interrupt. Just to say, you're sharing on presenter mode, not full screen mode.
Oh, I'm sorry. Right.
Sorry to interrupt. There you go.
Does that help? Yes.
Yes.
All right.
Yes, that's much better. Thank you.
Yeah. Right. Oh, hold on a sec. Now I need to go back. Right. Communicate with the contractor. If it's a contractor, you've been novated to a contractor. I had a case where I was ending up actually going to see a contractor, and they said, look, we would have considered paying you extra for money for these variations, but you didn't tell us about it. We've done our final account. It's all been signed off. So even with contractors, keep communicating with them. Very often they're more sincere about communication than the architect is. So always communicate with them. I've got to step over here now. Right, okay. So at a practice level, it's about utilization of staff, because profits will be eaten away by the underutilization. Everyone should be working on projects, and your cost rate should be managed on that basis. Just to highlight that, let me just move this out of the way. Just to highlight that, we have, if you think about staff costs, they're the biggest cost of the practice. They're your greatest expense and your greatest asset. You only understand their use if you fully resource them. It helps you understand spare capacity, helps you understand recruitment requirements, helps stop burnout from your current staff, and gives you time to make decisions. And something I always tend to go on about, which is profit is good. You know, it's needed for investment, research, covering loss-making projects, not yachts in the Bahamas, I should put there. It's good for the business, and it also helps mitigate risk by allowing you to have extra cash. And that is the end of my presentation. I'm sorry you got it halfway through on a presenter mode, but let me hand back over to you, Conley.
Jay, thank you very much. That's fantastic. Enjoyed that very much. So, listen, we're going to go into the panel discussion. There's just two points I'm going to make before we do. One is to the audience, please use the Q&A button, which is just at the bottom of your screen, to ask any questions, either direct questions to our panelists or more general questions or points that you want to make, and we will cover them in the last section. And to the panelists as well, right at the end of the session, I'm just going to ask you for a top tip on what people should be doing or looking at in order to kind of help mitigate risks. I just thought I'd give you a bit of warning before I do that. So onto the discussion. I mean, I thought I'd go back to Mac, I thought, actually. Interestingly, you talked about reasonable skill and care. And one of the things that I've taken away from from all of your talks, actually, is that although I'm not an architect, I worked in the construction industry for some years, that all the risks, are pretty similar, from getting your contracts ready, pricing properly, understanding when additional costs are, and communicating that to clients. But it all starts, doesn't it, with that contract at the beginning, Mac? I mean, it's really important to get that right, isn't it?
Well, yes. I mean, I suppose I would say that it is. I think that the one thing that I think was explicit in the Grenfell inquiry phase 2 report was that the fact that the project had started with certain members of the construction team not having their contracts in place was a good indicator that the project was, even at that stage, being mismanaged. And I think that there is, from my perspective, I've always felt that as a construction lawyer, there's something useful you can do in contracting at the start, which is that you get some agreement as to what your responsibilities are. And to the extent that you're able to see the services that others of the construction team are also providing and get to ensure that there are no gaps in that, I think that, from my perspective, is the usefulness at the outset of going through a managed pre-construction phase, a managed pre-services stage for you to work out where your responsibilities are. I also think that, from a sort of general risk perspective, as professional designers, you want to ensure that what you are doing is covered by your professional indemnity insurances, and unless you've got an explicit statement of what your obligations are, then you're going to have some difficulty in ensuring that all of those services are covered. So yes, As I say, I would say that, but I do think getting the contracts in place is an important thing to do.
Yeah. I mean, for lots of architect firms out there, and for people watching this, winning business is important. It's difficult, and when you win business, you can be just swept up in that. To like, let's get started, let's go. I mean, is it possible that, I mean, for medium-sized companies, I think probably in particular, maybe even the smaller ones as well, should they engage with a solicitor at the beginning, and maybe get something standard in place, which details, you talked about being very precise on what the scope and what your role is going to be within that. Maybe people may be thinking, oh, to do that, in every job, it could be expensive. Is there an argument to get a standardized kind of set of terms which links directly back to PI, and speaking to a law firm about that?
Yeah, quite. I mean, clearly there are REBA and the Association of Consultant Architects both produce standard form architects appointments that are reasonable forms to be used, and understanding the risks that you're taking on, getting your brokers or your insurers to check that those terms are covered by your PI insurance, things that you can do at the outset. It sort of depends on scale. For smaller practices, having short terms and conditions that are attached to fee quotes and the like are a good way to ensure that if there is nothing else put forward by a client, you've got something that covers you and is clear about, as an example, caps on liability. Without an agreement on that, there wouldn't be a cap on liability. So you would have uncapped liability without an explicit agreement. So engaging with someone, engaging with a standard form, understanding it, having something set out at the outset. It doesn't help you in every circumstance. Obviously, some sophisticated clients may have their own terms and conditions. Some projects might require some more sophisticated terms, but something that should be relatively good value for money is getting some early engagement, having some kind of standard terms that you work to.
I also think it's interesting that the client, or you need to understand the contract itself, even if it's an SFA contract. I mean, I've had a situation where it was old, I think it was SFA 99, where there was a clause where if the construction cost increased by more than 10%, you could go back and revisit the fee. The practice I was working for at the time didn't understand that. So they were signing the contract, not understanding in their case, they could claim additional fees.
Yeah. I'd like to just got a quick question for Laura now, actually. I mean, listening to your presentation took me back to my years of construction. I mean, and effectively, your buffer is what we would always term of contingency, and making sure you manage the costs that you're incurring and then communicate that to the client. I mean, that can be quite daunting when you're in it, when you're kind of in the process of a job, but it's got to be done, hasn't it?
Yes, it's got to be managed well. And yeah, lots of software can help you with that as well. And it's project management, and the lead on the job has to do that. You can't ignore it. And you also can't expect sort of, if you're in a larger practice, the finance director sort of to tell you about that. It's your project. You've got to manage it. You've got to look at the profit all the time. And this is even if you're just a 1 or 2 person architecture company up to, you've got 400, 500 employees. Everyone needs to know about the finances on the project. And I would even say, get the contract up there. I mean, not literally maybe, but with the scope beside you, so that everything you're doing, whether it's in scope or out of scope. It's difficult, but you've got to start negotiating. It's all about negotiation as well, and speaking to your client. And it is daunting, and they're sort of saying it's got to be done by this time. If you don't do it by this time, it will be delayed, and that'll be on you. So it's taking a step back and breathing. There's a lot of bluster which goes on as well, and it's sort of, okay, can they say that? Can they do it? Let me think of a cool head, which is hard if you're working, hopefully you're not working late nights anymore, but if you've got a lot of time pressure on you, etc., it's hard to take that step back. But that's why it's really also important to be monitoring everything like timesheets and the scope of what you're doing. And like Tahira said, having that that sheet or that Excel sheet documenting exactly what you're doing and where you've gone over scope, etc., and communicating that with your client. Yeah, it is daunting, but you have to do it. You've got to remain profitable.
Yeah, and it's a big part of mitigating risk, which is what we're here to talk about today. And moving on to Tahira, I mean, thank you so much for your presentation, and I really appreciate you sharing the dispute you had. The question I had about that, and hopefully it's a conversation point for the rest of the panel, was it felt like if you had spoken, do you think by speaking to the client earlier on about how you would communicate any additional costs, that the problem could have been resolved?
Oh, I think so. I think there's so many processes you can put in place. Like you can put an early morning notice, a tracker of some form in place. You can write project status reports, great. You can have a back-to-back appointment, fantastic. But nothing beats a good old conversation with your client. And I would always recommend people to pick up the phone and have a conversation. Take the opportunity, because there's always conversations that you have on email that gets misconstrued, tone can be changed. And actually, people don't always receive emails as well as they receive a good old conversation. So yeah, I think in that scenario, I mean, you have to bear in mind the scale of change orders on that project, what amounted to about quite a significant amount. So in the grand scheme of things, if you had to prioritize which battle you fought, which sums of money you would prioritize to get over the line, the 1,500 didn't feel at the time the right thing to do. But like with everything, you know, can't take the eye off the ball. And yeah, a good old kind of, we did the early morning notices, and maybe we'll follow through with a proper tracker, but a conversation on the telephone would have been, or even in person, maybe you had this meeting, would have really helped. Yeah.
Yeah, thank you. And Joe, I mean, what I was fascinated by what you were talking about when you said, because obviously you hear from a lot of architects firms, you know, about fees, and you know that they feel like they've got to cut fees in order to get work. And one of the things you said at the beginning was, well, maybe the fee, you know, it might not be the fee, maybe it's the scope that you need to look at reducing as a way of making it work. And I thought it was quite interesting. I wonder if you could expand on that.
Yes, I mean, it's, you know, you're proposing a fee for a amount of work, and you can adjust things two ways. You can either adjust the work you provide, the number of iterations of a particular design, as Laura said, I think it was Laura said that, you know, what you can do. So are you going to take on subconsultants? If you are, increase the fee. If you say, well, we can earn it for this fee, we won't take on subconsultants. I know this is difficult. I completely understand. I've been in these fee negotiations before, but the idea is really that you have the ability, by looking at the scope, to say, right, what can we possibly cut? What is there something that we can do to reduce that fee? And it's really important to understand. And if you can do more, then do more, but understand you're doing more. You're giving more value to the client.
Fantastic, thank you. Thanks for the audience for posting some questions. We're going to go on to do some of those now. So I'm going to I'll direct the question at somebody, one of our panelists, but of course, if anybody else has got anything they want to chip in with, please do. This first one is for you, Matt, I really think, because it talks about something you mentioned. So does the term "must take all reasonable steps to ensure" tend more towards a strict liability rather than a reasonable skill and care obligation?
Yes. Not the ensure, but the all reasonable steps. It does tend towards a higher obligation. There's a scale. I try not to have too many negotiations on between reasonable endeavors right up to best endeavors. That scale is effectively doing more and more things that are effectively to your own commercial detriment in trying to achieve something. and there is some relatively new formulation from a Qatari DR case, which I think is useful and is becoming more standard in the market, which is talking about all reasonable but commercially prudent endeavors. So it does mean that you need to look at all aspects of things that you're going to do, but not necessarily do things to your commercial detriment. And I think that formulation wording is now becoming more generally accepted in the market.
Okay, fantastic. Laura, got a question here from Luke for you, and he's asking, are there any advice on tried and trusted methods or formats to check the solvency of subcontractors using means that are proportionate?
Oh, this is, it says without inadvertently becoming their auditor. I was an auditor.
Yeah.
There's different things like Dun and Bradstreet offer a service. You have to pay for these though, but they can tell you straight out. I think one was called Credit Safe as well. They are subscription services. I mean, I generally went to Companies House because it's free, and I would just look to see if they've got cash, they've got net assets. So you don't have to be an auditor. Put it in Companies House, get their balance sheet up, see that they've got cash and they've got positive net assets. Otherwise, use a service like Credit Safe or Dun and Bradstreet, which will tell you how good they are at paying their suppliers. But they sample, by the way, so they might have hit one or two bad payments or not. But they also, if you don't have time, it can just give you a really quick rating. None are fail-safe, by the way, but it's better than nothing.
And are there any other ways that people can, do this by, looking at speaking to previous people they've worked for, or projects that they've worked on, perhaps, to figure out,
But I also do a quick Google as well, especially for overseas clients, because you can't get that information very well for overseas clients. Sometimes I go out to friends in the industry as well and said, okay, especially sort of maybe this will be overseas clients, and sort of say, okay, have you worked with these people? What are they like as well? It depends who you know, but if you can get some conversations going, that would be good as well, with your peers, that is. Yeah,
fantastic. And one for Tahira here, we've got one from Chris Foley, and he's asking, you said that 10% of subconsultants' fees was not enough to manage the process. Do you know roughly where the fee should have been sat?
I'd like to say what the project managers get. Let's get their fees and I'll take that. I think I'd probably like to say. Actually, no, we haven't done the exercise. What I do know is 10% isn't enough, but I would love to do a bit of a kind of deep dive into our timesheets and work through, which is something that I've been meaning to do actually, exactly what that figure looks like. So no, I'm just as much intrigued as everybody else, and it's something that probably should go through and understand better. But if anybody else on the panel knows what that region of costs looks like, please share with me. But I'm doing my own bit of research in the background to find out.
Yeah, fantastic, thank you. And I want for Joe here really, what are the most common early stage oversights or assumptions made when starting work on HRBs, and how can we proactively mitigate these risks during the planning and design phases?
Thanks for that. At the early stages, it's really about the resource. I mean, yes, we have issues about subconsultants, and they can be a substantial proportion of the fee, but it's about the resource. So really starting to fully resource out the project gives you that view about, should the fees be higher? What are the pain points? Are we going to end up going to site 3 times a month because it's down in Dorset? It's those types of information that give you that view about what could possibly go wrong. You won't know it unless you resource it out fully and see what the end result is going to be. Not answering that, but also just going back to a point about subconsultants. The other issue about sort of their contractual arrangements and fees for subconsultants is I often find that practices keep using the same subconsultants. Now, are they good? Have they been good? Did they perform in the past? None of that is ever noted. So you end up using the same sub-consultant that you weren't happy with on the previous project. So I always like the idea of value rating your sub-consultant, saying, like, do we want to work with them? Yes or no? Were they difficult about payment? Yes or no? So the ability to actually track and score each of your sub-consultants you use should be part of the process. But going back to the original question, it's about resourcing out the project.
Fantastic, fantastic. And there's a question here which I'll point over to Matt. I mean, it seems very much about the definitions at the beginning of a project, but so the lead designer role seems to be exploited but not acknowledged as scope creep. Any experience on how to deal with such a scenario?
Well, I will definitely bring in the colleagues on the panel to talk about that point as well, because there is a scope and service list that you would want to contractualize, but I think there is this question, I think, leads to a discussion about the practicalities of being lead designer and coordinating others' designs. So I'd welcome Laura and Tahira and Joe to come in on that point as well.
I always find this one of the most ambiguous things as well, actually. What does lead designer mean? And I've always taken it as I am coordinating a design team and pulling together everyone's work and be in a position to review, and I'm the point of coordination. I may have got that wrong, and that's because there's just a lack of clarity in that industry around what that involves. And sometimes I think I've found that clients have also not understood it and have thought we take on more of the project management role, and in some instances we've asked to commission surveys and review surveys and bring them in, and actually that's not what I would say. We would go out and find quotes and those things we wouldn't do, but it's that ambiguity, I think, for me, would be kind of getting some clear clarity somewhere, some guidance that sets it out on a more practical basis rather than kind of quite loose and ambiguous sets of kind of criteria.
Fantastic, thank you. And Laura, there's a couple of questions here talking to a point that you mentioned earlier, to do with monitoring costs and reporting, and then people are asking what kind of software or AI software is there available at the moment to help them do this?
Oh, software, that would be CMAP, I would say, because sponsoring this event. I think I saw one of the questions which was for really small companies. I mean, Joe would be better advised on to say what, does CMAP. I think it would probably work with a very small company as well. And there are other ones like Rapport's another one. Can't really remember. I mean, I know at Make we use CMAP very well. Excel at a very basic level. Is there an AI tool? I think AI tool in project management, or too early to say on that. But I will hand over to Joe, actually, because he's obviously the software expert here.
Well, thank you, Laura. I won't go that far. A small practice can have very large jobs, and those large jobs can entail substantial risk. So again, you want to go back and be in a situation where you know what those risks are at an early stage, and something that is engaging and is adopted easily. Architects don't tend to like figures; they much prefer graphs, and it's very simplistic, or not simplistic, a simple approach to what the result's going to be. CMAP is used by a practice of 6 people. It's an expensive way to do it, but they see the growth potential and also the way they can manage the risk from it. But equally, we've got businesses of 800 people, practices of 800 people. So it depends what the aim is, and it depends what the requirements are. Is it about an oversight? Is it about keeping control? Or are you happy, as Laura said, with an Excel spreadsheet, which is very flexible and very good, but is not terribly easily to engage with? We use CMAP at RCKA, and I think the 2 functions that I find very helpful, and actually I would recommend for
architects to kind of consider, whether it's in 3C map or another form, is forecasting. Forecasting, so you know exactly what you're setting out your baseline to be. And the other thing is all about actual data, because the actual data helps you then close that loop. So the next time you have a similar project, you know the types of resource is required, or the costs and the region of time is required, because the data is available. Both live data and historic data, and plugging that back into a new project is really helpful.
Thank you very much. I think we've run out of time. I mean, that's been fascinating. I think that's a great place to bring it to a close. So thank you all for joining. That wraps up today's seminar, and I hope you found this really interesting and as illuminating as I have. So many thanks to our fabulous panelists, Tahira, Laura, Matt, and Joe, for their insight and expertise. And once again, thanks to CMAP for making this webinar possible. And of course, thanks to you, the audience, for joining us today, with whom this would not be possible. There will be a recording of this session available quite soon, so please visit the Architects Journal website to find out more. Thank you for joining us. Thank you to our panelists. Thank you to our audience. Everybody, have a great day, and thank you all very much.
Thanks.